Mr. Minner, would you call the next case?
Chair Coleman versus Parkland School District, representing the school district, Mr. Timothy Gilsbach, representing Mr. Coleman, and J. Chadwick Schnee.
Good morning.
Good morning.
Under Section 709 of the Sunshine Act, prior to any scheduled meeting, an agency must post on the internet no later than 24 hours before the meeting an agenda listing every matter that will be deliberated at the meeting. If an agency does not provide such notice, Section 712.1 of the Act provides that the agency may not take official action on a matter of agency business except as provided in subsection B, relating to emergency business, C, relating to business arising within 24 hours before the meeting, D, relating to business arising during the meeting, or E, relating to agenda changes. In this appeal, we must determine whether subsections B through E constitute 4 standalone exceptions to the notice requirement, or whether subsection E is a separate provision which sets forth the procedure for amending the agenda only after one of the exceptions in subsection B through D is met. Please proceed.
Good morning, Your Honors. May it please the Court. My name is Timothy Edward Gilsbach, and I have the pleasure of representing the Parkland School District. The issue, as noted in this case, is whether or not there are 4 standalone exceptions to the 24-hour notice requirement.
Sir, could you pull the microphone up a little bit? I think you're a little bit taller than the last advocate.
There we go. Is that better, Your Honor?
Yes. Thank you.
Perfect. Okay.
And that way you don't have to slouch.
Yes. Understood. Thank you, Your Honors. And we believe that both the text of the statute, the structure of the statute, as well as the legislative history confirm 4 standalone exceptions. Let's start with the text of the statute. The text of the statute in it provides that subsections, the exceptions are in B, C, D, or E. In the traditional rules of statutory construction, the word "or" means if there's a list of items, any one of those will meet the requirement. And therefore, the only other way to interpret that, as has been proposed by both both the Commonwealth Court as well as appellants, is to replace the word "or" with the word "and." And that could mean one of 2 things. On one hand, it could mean "and," and all 4 of those need to be met. Clearly, that's not the case. Everybody agrees that any one of the other 3 by themselves is enough. But instead, what they have proposed is sort of reading it as a word "and," but more of a sort of, well, you can meet one of those 3, and you've got to meet this 3rd requirement. But the statute doesn't say anything like that. There's nothing in the statute that would remotely suggest that's the case. In addition to that, if you look at the structure of the statute, that confirms that understanding. Because while it might be rational to look at subsection E and say, well, wait a minute, that perhaps is a mechanism to apply these other 3 exceptions, subsection F very clearly is a mechanism by which you apply the exceptions. Subsection E and subsection F is not listed in subsection A. So what you have is, on the one hand, you have subsection F. Everybody agrees that's a procedural mechanism. On the other hand, you've got subsections B, C, and D. Those are clearly exceptions. Subsection E is treated in the same way as the exceptions, not the procedural requirements.
F specifically talks about items added to the agenda, and only E expressly talks about adding items to the agenda.
I'm sorry, Your Honor.
Subsection F
Yes.
talks about items added to the agenda, right?
Yes, at the meeting.
And only E speaks specifically to items added to the agenda.
I think, as I interpreted it, subsection F is what you have to do if an item is added to the agenda.
Right,
the
but
procedural requirement.
of the list of B through E,
Yes.
only E speaks about adding an item to the agenda. There's nothing in B, C, and D that talks about altering the agenda.
I understand. Sure, I understand. I hear your question, Your Honor. And I think that...
And on top of that, F talks about in this section, adding an item to the agenda in this section.
Correct.
Right. But again, B through B, C, and D do not talk about altering the agenda. Only E talks about altering the agenda.
Correct, I understand, and I think that the reason that they do that is that subsections A, B, C, and D speak of various options of the types of items you can do, but subsection E provides a mechanism, and in fact, it's the only mechanism with the board itself can amend its own agenda should it choose to do so at a meeting.
But you said E is independent.
We believe E is independent, yes.
I know that's, I'm trying to understand that because you went to F.
Yes,
And F speaks in terms of items added to the agenda.
correct.
B, C, and D do not require any alteration of the agenda.
Well, I don't know that the board, I think the board would have to amend its agenda if you're going to take an action under B, C, or D.
Then what's the
Essentially-
point? What's the point of E? What's the point of B, C, and D if E covers all of them?
No, it doesn't cover all of them.
That's a fair question, and our position is that ultimately that's an issue that should be sent to the state legislature. And
See,
part,
I'm going to push back on that for a
go
minute.
ahead.
I do have problems with the Commonwealth courts wrestling with what "or" means.
Sure.
But in light of E and in light of F, I wonder whether there was a scrivener's error of some sort here in listing B through E. And maybe it should have been B through D, because B, C, and D are specific things, specific topics. E is not the type of thing we would expect to be in a list like that. E is a procedural device that would seem to cover the items that preceded in the list. And you started with the idea of when items are in a list and there's an or, they're all supposed to be treated independently. But that list has to be similar in kind and subject and standard. E does not look like B, C, or D.
Excuse me, Your Honor. I agree. E is clearly much broader than the other exceptions. But the issue, of course, you have is that the state legislature. This wasn't simply an issue of they made a mistake in drafting the statute, because subsection E is specifically listed in subsection 8. Subsection F is not, and I think that's.
That's what I'm saying. You're assuming that isn't a mistake. Why are you assuming that's not a mistake?
Because if the purpose of subsection E is a procedure, just as subsection F is a procedure, those are separate. That would not be included in the specific language that says you give 24 hours notice unless, and then there's this list of these subsections, and it includes all of
So
those.
if I could follow up then.
Sure.
In A, we read, except as provided in subsection B, C, D, or E. An agency may not. So why is it inconceivable that the General Assembly would have given us both substance and procedure in that litany? In other words, that B, C, and D spoke to substantive exceptions, right? And then E, except as provided, so E is providing a process for this.
Sure. Understood, but the where you run into a problem with that is, first of all, that's not what the statute says. The way you're reading it that way, what you're really saying is, except as provided by subsection B and E, or C and E, or D and E. Essentially, what you're saying is they would have to meet both the requirement of B, C, or D, and meet the requirement of E. But that's not what the statute says. And certainly, and again, I think the appellee raises concerns about public policy and the like. That, if in fact the state legislature made a mistake, they can go back and fix it. And in fact, the plaintiff in this case is uniquely in a place to do that. He is a member of the state legislature. If he felt that the state legislature made a mistake, they can amend it and go back and fix it.
The question goes to the question of whether the statute is ambiguous as
Sure.
it is written. And you look at the entire section, you don't look at the one word. You have to look at the section as a whole.
Sure.
And I'm having a difficult time, and Lord knows I don't find ambiguity too often in statutes, but this statute seems, there's at least a very good argument of different interpretations of this statute, given how it is set forth, given how F is worded, given how E is not worded the same way as B, C, and D. Just looking at the entirety of the statute, why is it not reasonable to say that it's ambiguous, and we apply the principles of statutory construction to determine what the legislature's true intent was.
Sure, and if you go to that point, and that...
So
sure,
your
let's
primary
just-
argument is it's not ambiguous.
I do not believe it is ambiguous, simply
Well, then,
because...
if it's not ambiguous, what was the purpose of having B, C, and D? You didn't need them. You just have E, and that devours everything, right? If you're right, and there's no ambiguity, then why would you need B, C, and D?
Well, I think the short answer is, I think certainly the legislature may have said, look, these are the things we anticipate this will occur under. These are the kinds of circumstances, but also leaving the reality that there may be circumstances outside of those three
But
ranges.
a majority could, pardon me, but what am I missing? So if you're right, and I was thinking, when I was reading Judge McCullough's dissent, I was thinking this, if you're right, and E is doing what you're talking about here, would I be correct that you don't need B, C, or D at all? It would be like saying, except as provided in, well, I'm not coming up with a hypothetical, but they've sketched out these three scenarios, B, C, and D. And then the or is this other category, E, which is everything. A majority can do whatever it wants anytime.
Correct. I understand your concern, Your Honor, and sure, that is a concern. The one subsection does talk about concerns raised by the public. Presumably, that's something that the state legislature had concerns about. And I think too, if you move to the phrase of it's ambiguous, we start to look at the legislative history. The only reference anywhere in the legislative history about the number of exceptions is when this was reported out of committee, and they said 4 exceptions. That is, there is conversations about, in general terms, that there's exceptions, but the only specific reference anywhere in the legislative history about the number of exceptions is when this was reported out of the committee. I believe it was in the House, in which they said 4 committees.
Let me just try one more time, and then I'll stop on this.
Go ahead.
So, under your reading, and tell me if I'm wrong about your reading, under your reading and the dissent's reading, under the rubric of E, the board could, by a simple majority, change the agenda in any way it deemed appropriate, and period. And therefore, the pains to which the General Assembly went in enumerating B, C, and D were a complete waste of time and essentially entirely meaningless.
Well, if you read the text of the statute, that's absolutely 100% correct. I think what you're hearing, counsel, is individuals on this court who are textualists who say we don't want to look at the General Assembly's intent, we want to look just at the text. Yet the clear intent of this particular statute was for notice to be given to the public. What Justice Weck is pointing out, that if we accept what your version of this particular incident is, or your reading is, E eats the entire statute because it circumvents A, B, C, and D, correct? And your position is that probably, it's textually speaking, that's 100% correct, but the General Assembly should fix this because it's their screw-up.
Fair enough, Your Honor. Yeah, that is essentially the position I'm taking. Yes,
So
I do
Before
believe...
you take that position,
I'm sorry.
before you take that
Go
position,
ahead.
could you look at it from a different perspective, that even if you are a textualist and you're reading this exactly as written, that E does not really mean that the items in A through D would ever have to be included in an agenda, but rather would be covered under the situations that arise on A, B, C, and D, and then reflected in the minutes post-meeting rather than ever being added to the agenda. Is that a plausible reading?
I believe you could read it that way, yes, in the sense of, excuse me. Yeah, I believe you could read it that way, that E is sort of, we're changing the agenda, the other things may come up, they may do something with them, maybe.
And don't necessarily need to be part of an amended agenda. They're just handled during the meeting to be reflected later in the minutes. Is that reasonable?
Sure, and especially with respect to subsection D, and having sat at numerous school board meetings, the public raises a concern. It very clearly says the board can direct an administrator to go do something. Sure, that would not be an amendment to the agenda.
Well, and if that's the case, then maybe there's no Scrivener's error and maybe there's no ambiguity.
Well, except you have to deal with F.
Well, I was only getting to E.
I mean, I think that's a fair reading, except for F. The problem with F is it makes it look like everything in B through E is added to is an amendment to the agenda.
Yeah, I believe, Your Honor, that would be. Well, it says if action is taken, and I guess the question becomes,
but it specifically says added to the agenda.
Yes, it says the minutes shall reflect it, but it also says added to the agenda.
Right.
But it also talks about
under this section.
Sure, and I also say, but also the other component comes up that's if action, and I guess the other component that comes up with that too is specifically when I'm looking at subsection D, there may not be a formal board action. It might more be go do something to the administration, I think. So that's, my interpretation of it is, I don't believe it's ambiguous. I think that they use the term or, and that means or. That means anything in that list is appropriate. And the cases that are cited both by the Commonwealth Court and by appellee that talk about sort of using the word or to mean and, are not in this context in which we're in a list of exceptions. It's instead when we're in a context in which the specific case were potential penalties that could be applied, and I apologize, I forget the name of the case, but there were specific penalties, and the court basically said, okay, yeah, you can put one or all of these. In that context, that's a different context. In this context, we're talking about exceptions to a general rule. And when you use the language or, the statute's very clear. In terms of statutory interpretation, that means or. Any one of those four would meet the requirement. And to the extent that there are concerns that sort of that exception interpreted that way would sort of eat up the rest of it, I think that's a legislative issue that goes back to the legislature and says, well, okay, you've done this. If it's not working, or if there are these parade of terribles that some of the amicus pointed out that might happen if boards can do this sort of thing, then the way to fix that is go to the state legislature. Lastly, I would note, especially in the context of school boards, these are elected officials. At the end of the day, if they start doing all kinds of crazy things at board meetings and adding things without people showing up, they're subject to the electorate. And prior to 2021, there was no limits on the ability to do anything. There was no requirement to provide notice prior to 2021. So the state legislature created a clear general rule, but clearly created exception. And I believe that subsection E creates an exception that permits for the very real reality that there are times things will come up that aren't considered in the other exceptions.
All right, any other questions?
Thank you, Your Honors.
Thank you. Let's hear from opposing counsel, Mr. Schneek.
Thank you, Justice. I'm going to lower this because I'm much shorter. My name is Jay Chadwick Schnee. I'm here on behalf of appellee Senator Jerry Coleman. And I noticed that Chief Justice Todd mentioned justices in the courtroom and some portraits outside. I wanted to reference a different justice, Justice Brandeis, who once said that sunlight is said to be the best of disinfectants and the electric light the best policeman. And this is what this case is about here today. It's about open meeting requirements and the Pennsylvania Sunshine Act.
Just won over Justice Wex simply by quoting Justice Brandeis.
That's a good rule of thumb. Do you know that when Brandeis was at Harvard Law School, speaking of light, that the lighting was so bad that his eyesight was damaged, and until he recovered, he had to have another student, a friend, read books to him. And he still collected the highest GPA ever there.
That's impressive.
But it's only Harvard, so, you know.
Counsel, if you can weave in a quote from Oliver Wendell Holmes, I think you can just walk out the door and drop the mic.
Unfortunately, I don't have any in my back pocket, Your Honor. I apologize.
You can submit a post-argument.
Well, fair enough. And I think the issue here today is what Justice Brobson and Justice Wecht and others mentioned, is that appellant's argument really renders subsections B through D of the Sunshine Act.
Well, that's not really true, because E requires majority vote of all the individuals present, and section B and C and D do not have that requirement.
Right, and actually subsections B, C, and D have no requirement or no procedure and no process about how an agenda is amended. Only subsection E does. And so subsection E requires that the reasons for amending the agenda be announced.
No, I don't read it that way. I read it that B gives you a special exception to amend your agenda when you have an emergency meeting on a matter of agency business relating to, and the Act specifies very clearly in subparagraph B. C allows you to add business within 24 hours before the meeting, as specified in section C. And D allows you to add business arising during the meeting if you meet the requirements of subsection D. But only E requires upon majority vote of the individuals present. So whether or not E may include the items included in B, C, or D or not, it's contingent on you getting a majority vote of the members present.
Well, and Justice Mundy, I would respectfully submit that all agencies can only act through a majority vote of a quorum of its governing body.
Well,
So-
absolutely, but you could have less than a majority vote saying we don't want to hear it.
Well, right, but in order for emergency business to be conducted under subsection B, a majority of the board has to say, we want to take this action. In order for any action to be taken under subsection C, a majority vote of the members present have to take action on it. Same thing with subsection D. And I think subsection C really highlights, in this particular factual scenario, the problems with appellant's interpretation. So subsection C, as Justice Mundy pointed out, provides that for business that arises within that 24-hour period between when the agenda is posted publicly and when the meeting occurs, an agency can't take any official action on that item unless it's de minimis in nature, it doesn't involve a contract or an agreement, and it doesn't involve the expenditure of agency funds. In this particular case, the record before this court, reproduced record page 79A, provides that the reason why the collective bargaining agreement at issue here wasn't on the agenda was because that day the teachers union had voted to approve it. And so it arose in that 24-hour period. So if subsection C prevented the district from taking any action on this collective bargaining agreement because, one, it's a contract, two, it does involve the expenditure of funds because there's a 2.9% pay increase in there, and three, it's certainly not de minimis in nature because it involves the terms and conditions of employment for hundreds of district employees, the district could not take any action under subsection C. So to Justice Weck's point, subsection E would swallow the whole. You know, it would render completely this prohibition under subsection C meaningless.
So why isn't that an issue for the General Assembly to take up, since they were the ones that drafted it, and they basically drafted a statute that provides for one subsection to swallow the rest of the entirety of the whole? In other words, why are we being asked to fix their mistake?
Well, Your Honor, I think the problem is that's what this court is designed to do, unfortunately, to a certain extent.
Yeah, but there's nothing, we can only do so if we find an ambiguity in the text of the statute. The statute's pretty clear.
Well, I think every member of the Commonwealth Court below found that it was ambiguous in some way. So the majority certainly found it was. Even the dissent, Judge McCullough's dissent, noted that there were clearly some irregularities.
Tell me what you find ambiguous.
Well, I think the problem is is how do you interpret subsection E while giving any effect to subsections B, C, or D?
Yeah, but that's not an ambiguity. I mean, that leads to an absurd result.
Right, and under the rules of statutory construction, we certainly can't have an absurd result. That's not what the General Assembly intended.
Actually, under the rules of statutory construction, you can have an absurd result. As long as the General Assembly passed an absurd statute, you can have an absurd result.
Fair enough, Your Honor.
I mean, you don't get to let me be careful. You don't get to the statutory construction presumption of absurdity against absurdity unless you apply the rules of statutory construction. You don't apply the rules of statutory construction unless the statute is ambiguous.
Correct, Your Honor. And what I would say to that is under the rules of statutory construction, the way you interpret the plain language of a statute is within its surrounding context. And so going back to subsection A of 712.1, it doesn't make the surrounding context doesn't make any sense. The entirety of section 712.1 provides reasons for amending an agenda and a process for amending an agenda.
Yeah, I want to ask you about the agenda thing. Who creates the agenda for the school board?
So I think that very likely differs between each individual district. I would suggest.
Well, I'm thinking about this school board. Who creates the agenda?
I don't know the answer to that, but I would suggest it's probably a combination of the superintendent and the school board president.
Right, it's not the board itself. So if that's true, maybe E is a standalone, because the board doesn't create the agenda. The board meets, it confers, it deals with business. So maybe the statute B, C, and D is sans agenda, has nothing to do with the agenda. It just allows the board to take action off agenda under certain circumstances. And if those circumstances aren't present, it has to go to E and actually formally amend the agenda, a document that they didn't create in the first place.
Well, I think that respectfully ignores some of the realities when it comes to school boards. You're dealing with elected public officials that are working for no pay, that are really deferring their functions in a lot of ways to the superintendent and sometimes the board president. So if subsection E is its own separate standalone exemption, there's no reason to have a separate subsection for emergency business, for example. There's no in subsection D, if a resident or taxpayer, which could include a member of the governing body, for example, raises an issue to the board during a public meeting, the agency still can't take any official action other than to refer it to staff unless it's de minimis, doesn't involve a contract, and doesn't involve the expenditure of funds.
In other words, just a similar question I asked opposing counsel. Is it your view that if appellant is correct, if the dissent is correct, then all the work done by all the work done by B, C, and D could be done by E?
Correct. There's no other way to read that, because if, as I said here, with the collective bargaining agreement at issue here, it arose in that 24-hour period. They could not operate under subsection C. It was a prohibition. But then they're arguing here today that subsection E allowed them to do whatever they wanted for any reason. You know, and I think what's important to know too is that appellant didn't identify what reasons they had to list, right? So it could be any reason.
Yeah, but
so
counsel, they're making that argument because the statute says they can do it. I think that's the problem we run into. I mean, I'm the newest member of this court, and I'm struggling with text versus intent. I mean, we often have people come in here on both sides and read the same exact intent or statute and tell us it means completely different things. In this particular case, we had an amicus brief, I believe, by the Republican Senate, where the Republican legislature said, no, we didn't mean what we said. We meant something else. Our intent was something else. So what are we to do with that particular argument?
Well, I would say, actually, Your Honor, I would point you to subsection E, subsection 1, which talks about the reasons for changes to the agenda shall be announced at the meeting before any vote is conducted. Those reasons are contained within B, C, and D. So in terms of the Republican caucus's argument, I think they did a very nice job of talking about the legislative history.
Sure.
I'm honor-bound to say that.
Then the text says something else? That's what we're struggling with. I think what you're seeing here is, twisting yourself into a pretzel to figure out, we know what the intent was. The intent was clearly, as you just pointed out at the outset, the quote from Justice Brandeis, the intent was to let the public know what's on the agenda so they could come to the meeting and have a voice and be heard on those particular subjects. Subsection E basically allows the board to do whatever they want to do and not let the public know and then tell them afterwards what we did, which, technically speaking, violates both the spirit and the intent, but not the text.
I would agree with you, except for your last point about the text. I think it does violate the text because the only way to read Section 712.1 together, giving effect to all of its statutory provisions as the rules of statutory construction require, is to read it as B through D give the reasons, subsection E gives the process. And the reasons that...
Then why didn't the General Assembly say that?
Sometimes the General Assembly is not the model of clarity, Your Honor.
Sometimes.
Counsel, I guess the problem I have with this is you're not asking us to interpret this statute. You're asking us to rewrite this statute. You're asking us to read or E out of this, and frankly, I don't know how you get beyond it. I mean, I understand all the arguments that we're hearing about they couldn't possibly have intended that. Well, if we say we're interpreting this statute as written, it seems to me to be an easy fix for the legislature to go in and take out or E and change it to B, C, or D, and then it's over. I mean, but we have to rewrite this. And if you're arguing it's ambiguous, and we start looking at legislative history, maybe yes, maybe no, legislative history refers to 4 exceptions. So are we supposed to ignore the fact that it refers to 4 exceptions when there are 4 exceptions? You see what I'm saying? I mean, if this is an obvious an error, as you suggest it is, to me, the only way to fix it is for the legislature to fix it.
I would say 2 things. One, on the legislative history front, those were remarks made by a House staffer, not by a member of the General Assembly. So I'm not necessarily sure how much weight it holds.
Right.
And then
Not a whole heck of a lot.
Well, but our law also doesn't give a lot of weight to the statement of a single legislator either.
Correct.
Legislative history is amendments. You know, what amendments were made at this point, what did the bill look like, what changes were made. Statements of a single legislator are not legislative history.
I agree, Your Honor. I take that point. And I think the Republican caucus does a nice job of spelling out the legislative history here. But the other thing I would point out to Justice Donohue's question is what the Commonwealth found in page 11 of their opinion, which noted that the conjunction or must ordinarily be given disjunctive meaning unless such construction would lead to an absurd result. And that's exactly why we're here today, because it does lead to an absurd result. So even though it uses the word or, and even though that's not a model of necessarily clarity, in this case, because it leads to an absurd result, because E would swallow the whole, E eats everything, that's our argument here today. And the only other comment, if I could, Chief Justice, is the other aspect, the other problem with this is that it really prevents the public from having the ability to really meaningfully or offer any kind of public comment whatsoever. Because if the public has no notice of what items are going to or may be before a government agency, they may choose not to attend. And if they choose not to attend and an item is added, they have not witnessed the deliberations of the agency, borrowing from the language from Section 702, subsection A. And if a person shows up at a meeting, that person is likely going to be completely unprepared to offer any kind of meaningful or robust public comment on whatever item is added to the agenda, because that person had absolutely no prior notice that the item would be at issue during that meeting.
And that argument would be germane if we find this ambiguous, which it pretty clearly is ambiguous, and we are probing for the purpose of the statute, right?
I agree with that, Your Honor.
All right, thank you very much,
Thank
both
you.
of you. Mr. Minner, would you call the next case?